Hi, I'm Katie Ash. I'm a solicitor and head of the employment team at Banner Jones Solicitors. We've been helping clients with legal issues arising from the coronavirus pandemic, and we've produced a guide to help clients understand what support might be available for them. We've also introduced a fixed fee package to provide employment law support to people wanting to understand the coronavirus job scheme and understand what support might be available for them under the government's scheme. That's a fixed fee of £400 plus VAT for advice and documentation to ensure that you're legally compliant in implementing that. In terms of the guide, I thought it'd be worth just covering 5 points that you should be aware of, but obviously there's much more detail in the guide, and I'd urge you to have a look at that. First of all, check whether you can claim. The government say that any employer who has a PAYE scheme open on the 28th of February will be able to claim a grant under the scheme and claim a contribution to employees' wages of up to 80% of their salary, capped at £2,500 per month. That's all employers, so that includes agency workers and individuals who might employ people individually, such as nannies, provided that they've got a PAYE scheme. What you need to know is that there are conditions on implementing that, and the government have intended this scheme to be open to anyone who is impacted by the circumstances arising from coronavirus. That doesn't necessarily mean that you have a redundancy situation. It may be that your staff can't come to work because they've got childcare issues or they're shielding, and you can use furlough in those circumstances. What's really important there is that you document the agreement by the employee to be furloughed. It's not sufficient to notify them. When your employee is on furlough leave, it's really important that you don't let them do any work. It's a condition of the grant under the scheme that employees do no work for you. They can't work for a linked employer either, so if you're part of the group, they mustn't be doing work for a linked employer. They can volunteer for organisations if that's recommended by the Public Health England, in England and Wales, and they can work for other employers. They just can't do work for you if they're under the furlough scheme. As I say, it's really important that you notify them that they're on furlough and that you document their agreement to be placed on furlough in writing. Not sufficient just to do that verbally, you really must have that documented, and you must retain those documents for 5 years. And it's likely that HMRC, having retained the right to probe into these grants, will do so. So really do need to have something in writing. When your employees are on furlough, they can't do any work for you, but they remain your employees. They're still entitled to all of their employment rights. Annual leave will accrue, their length of service will continue, and that might be relevant going forward in the event that you need to look at workforce changes and maybe redundancies, and of course discrimination rights continue as well. So I hope you found that really helpful. I hope you find the guide really helpful. As I say, we've introduced this fixed fee package to help businesses, and of course if you've got any queries in relation to employment law or anything else affecting you or your business, then please give us a call.